So this evening's discussion lecture is on California's political and election laws, which is different, of course, than direct democracy, which we'll cover as well. Last week we had a guest lecture from Richard Rios, the managing partner at the Olson Remshow firm, one of the most prestigious in the state on political and election law. And so this is essentially my take on it. From my perspective, political and election laws are the main distinction is that the elections related stuff comes initially from the Constitution, Article 2, which deals with voting and direct democracy. And then by statute, those provisions are found in the California Elections Code, as opposed to political laws, which we designate as those that are in the government code and that originally were put forth, excuse me, by the voters in 1974, which of course is Prop 9 in the Political Reform Act or the PRA. So those are the political and election laws, again, initially stemming from Article 2. And then on the Political Reform Act, some of it is in Article 4, dealing with the legislature, things like the revolving door prohibition and conflicts of interest, gifts and honoraria. Those are all there, again, to be separated from the provisions of Article 2 dealing with the direct democracy, the three forms of them. So starting on the election side of things, the Elections Code, of course, is one of the 29 codes in California law containing the statutes related to running elections in California. There are 22 divisions in the Elections Code. So overall, there are about 2,280 sections. So not particularly large amongst those 29 codes, but there's a lot of stuff in there. As a broad overview, there are, of course, preliminary provisions. The 29 codes have either preliminary provisions or general provisions, they're called. Following in the Elections Code, you have election dates, information about voters. Then Division 3 is dealing with vote by mail, which those who are registered to vote for November 4th will have gotten your vote by mail materials to submit those. Things dealing with new residents of the state or new citizens to the country and how they register to vote. We have materials or code sections, excuse me, about political parties in the state. Then we go into presidential elections. Of course, those are held every 4 years, but the states, through generally the local counties, such as the 58 counties in California, are actually the ones who are conducting those elections, of course. We have then political party organization and the role of central committees. We have a whole area in the Elections Code dealing with nominations to state office, the federal nominations for, I'm sorry, the nominations for federal office. And then we get into some of the provisions implementing Article 2, direct democracy, dealing with measures that are submitted to the voters. And then we have local or special elections and the consolidation of them. The Elections Code covers recall elections. We have both pre-election and post-election procedures that are covered. We have a lot of material related to ballots, including the voter pamphlet that accompanies those ballots. Of course, this one was relatively small for November 4th since there's a single statewide ballot measure. In some jurisdictions, you will have some local measures. And of course, we don't have people, candidates for office, local, state, or federal, on this special election. Then the elections code goes into actual election day procedures, not just for voters, but also for the registrar of voters and election workers. We have what we call the canvass, both the semi-official and the official ones. This is basically the statement of the vote. The elections code gets into recounts and election contests when somebody challenges the result of an election result. There are also specified provisions for how the 58 county registrars of voters must retain and preserve election records. For certain violations, there are actually penal provisions, meaning criminal penalties for violating specified provisions of California's elections code. And then we have the provisions implementing Article 21, which is, of course, redistricting. California voters established the Redistricting Commission. And so we also have statutory provisions to implement those congressional provisions, and those are found in the California Elections Code. The Elections Code, of course, has some important initial provisions, and the role of California's Secretary of State. The Secretary of State, by law, is our chief elections officer. There are some constitutional provisions related to the Secretary of State in Article 5, which deals with the executive branch of government. Recall in our first course when we talked about the executive branch, we discussed the fact that California has what we call um, rather than a unitary executive, like at the federal level, right? Just the president. And then everybody else is appointed, like the Secretary of State at the federal level, the treasurer, the controller, the attorney general. In California, we don't have a unitary executive. We have a plural executive because all of those constitutional officers are not appointed. They are elected to office by the voters. But you have to look to both the government code and the elections code to find the specified roles of these constitutional officers, including the Secretary of State. And as our chief elections officer, Dr. Shirley Weber, she is required to do a lot of things in conducting those elections. The government code specifies that the Secretary of State has to make reasonable efforts to promote voter registration, to encourage voters to vote, eligible voters to vote, to promote registration, and to promote civic learning and engagement, to prepare both students as well as new citizens of their rights to register to vote and to vote. Also, the Secretary of State is actually required to prioritize communities that have been historically underrepresented in both voter registration or voting itself. And the Secretary of State is required to conduct public election campaigns, providing materials to promote and encourage both voter registration and participation in voting, as well as in the decennial census that, of course, happens every 10 years. The legislature established in the Secretary of State's office what they call the Office of Election Cybersecurity. So we actually have an office dedicated to protect our elections and to require the Secretary of State to work with the 58 county registrars of voters. And of course, as you can imagine from their name, the goal is to reduce any cybersecurity incidents and to ensure that our elections are secure and that the integrity of those elections are always maintained. And so that is the primary role there of that particular office. There's also requirements imposed upon the Secretary of State to assist candidates in filing their declarations of candidacy, or if they're securing signatures for those nominating papers, and to assist them in, uh, completing and submitting all of those materials to ensure that those who are running for office and want to appear on the ballot, in fact, are able to do so. They're also, supposed to ensure that those that are legally qualified, submit all the required materials under penalty of perjury, as you can probably imagine. Now, it's also important that the election procedures in the elections code, again, deal with the three levels of government, right? Federal, state, and local. And at the local level, we also have a number of local county-wide officials who are actually elected by those county citizens, the voters of those individual counties, including the auditor, in some instances, the registrar of voters, certainly the district attorney and the sheriff for law enforcement. Perhaps a county has a superintendent of schools. A number of jurisdictions have either a treasurer or a tax collector. There are a few counties that actually combine the two and have a county treasurer tax collector role. Judges of the Superior Court in the 58 counties can also run for those offices. Otherwise, vacancies are filled by gubernatorial appointment, and then the so-called Jenny Commission actually confirms them rather than the state Senate, who are normally called upon. One of the key roles in 2002, the federal government um, they enacted the HAVA law you may have heard of. HAVA is Help America Vote Act. And so there are quite a few provisions of federal law that impose requirements on the states, and therefore, at least in a state like California, get pressed down, if you will, to those 58 county registrars of voters for them to ensure compliance. I wanted to highlight some of the what I view as some of the unique aspects of the electoral system here in the state of California. As we've talked about before, of course, we have those 9 constitutional offices. Technically, the ninth is the Board of Equalization, or the BOE, or some refer to it as the State Board of Equalization, SBE. There are technically 4 districts, so 1 through 4. The 5th member of the BOE is the controller by nature of her position. So that 9th office is actually 4 members of the Board of Equalization, with the state of California divided into 4 BOE districts. And those are also redrawn every 10 years as well. And then, of course, we have the 120 seats in the California legislature. All the constitutional officers are prohibited or limited to serving 2 4-year terms. Often get the question, how did Jerry Brown serve 4 terms? Well, his first 2 terms in the 70s primarily were before term limits. Term limits were 1990. And so he got to serve those additional. So no one will ever again serve 16 years as California governor unless, we obviously modify the term limits law. For the legislative offices, obviously the assembly, they run every 2 years. State senators every 4 years. So every 2 years, all 80 seats are up. Half the 40-member Senate seats are up every 2 years. So the ones that are not up for election, we call them carryover senators. carry over to the next 2-year term. Like we'll go over this more in course 4 on which is entirely dedicated to the legislature, legislative process, and drafting. But every 2 years, the legislature, just like based upon Congress, they enter into a 2-year or biennium session. And so we call them carryover because they're carrying over to the next 2-year session. Due to the voters modifying the term limits law, it used to be a maximum of 3 2-year terms in the Assembly and 2 4-year terms in the Senate for a total of 14. The voters modified it prospectively. The legislature tried it once before, it failed because it was going to grandfather in, so giving the existing legislators even more. That failed. The current one is 12 years maximum. That's a lifetime in either house or a combination of the two. So you could spend the whole 12 years in one house, or you could do, 4 years in the assembly and then 2 2-year terms and then 2 4-year terms in the Senate, and that's your 12 years. By the way, after the 1990 term limits law, the original one, often referred to as the Shabaram initiative, that's because former LA County Supervisor Pete Shabaram was behind it. The legislators at the time challenged it up to the California Supreme Court, which upheld that, and they also upheld the challenge for a lifetime limit. In other words, legislators argued unsuccessfully that they should be able to step out for 2 years, for example, and then get a new, under that law, 14 years, right? But the Cal Supreme Court said no, the lifetime ban is constitutional. So that's all you got. Anyways, some other things I wanted to touch upon in terms of the unique nature, again, from my perspective. Judicial elections. So, of course, at the federal level, we know by Article 3 of the U.S. Constitution, federal judges, district court, court of appeals, U.S. Supreme Court, lifetime appointments, and they are appointed by the president and confirmed by the Senate, and that's it. California judges at the Superior Court level, the trial court level, can run, but for the most part, judges are appointed by the governor. But then the Judicial Nominations Evaluation Committee, JNE, the Jenny Commission, they're the ones who confirm it, confirm them. As opposed to at the federal level, the U.S. Senate confirms. We have an independent body, the Jenny Commission, that does that. Also, we have what's called a retention election. And the retention election is every 12 years, judges, Court of Appeal, and the Cal Supreme Court are subject to a retention election. And basically, the voters are asked, shall this, this judge or justice be retained? Meaning, do they get to keep their seat? The most recent California Supreme Court Chief Justice, Tani Kantil Sakaui, she decided that at the end of her 12 years, that she had been appointed by Governor Schwarzenegger to the High Court. She was on the Court of Appeal from Governor Wilson, and she decided that at the end of the 12 years, she was going to step down. So she didn't stand for election before the voters. Now, you may recall, if you've studied California history at all, that in Governor Jerry Brown's first term in the 70s, that 3 Supreme Court justices lost their seats. Most people, Justice Rose Bird was the main one, the most well-known one. And she, of course, was the Chief Justice, and 2 associate justices, they call them. There are 6 of those, plus the Chief Justice is the 7. And uh, most people mischaracterize those three justices as being recalled. They were not recalled. Bit of cocktail trivia. They were removed from office because the voters did not confirm them. So they were subject to a retention election, and people argued that they should not be retained on the court. And the voters, there were more no votes in the retention election than there were yes votes. And so they were not recalled from office. That is a separate process that we'll get to in direct democracy. They were simply not retained. The last time that a judge was recalled in the state, if I got my records correct, was June of 2018. A Superior Court judge was recalled from office. The voters in that area believed that this judge had imposed too light of a sentence on on somebody who was found guilty of sex offenses under the penal code. And this judge, their perception was that he imposed too light of a sentence. And so he was recalled from office. That is the most recent recall of a member of the judiciary. So now, the fact that some run for office, like in California, is not totally unique. In some states, the appeals court justices, intermediate court or the court of appeal, or the highest court generally is the Supreme Court. Although in New York, I don't know why the Supreme Court is actually the trial court level. Makes no sense to little me, but anyways, there are instances where even those for the high court can seek election to that position. Most limited to the trial courts, but there are some higher court instances. I think the other unique, or another unique, this is not the only one, another unique provision of California election law is the top two primary. Historically, California followed, sort of the normal approach, and the highest Democrat Party vote getter faced off against the highest Republican Party vote getter. Beginning with that June election is our primary, except in presidential years, in which case it is moved up to March. And then, of course, November, the first Tuesday in November, is the general election. California voters, more than a decade and a half ago, they changed the law to a top two primary, meaning, of course, that the top two candidates in that primary, June in the off presidential year, March in the presidential year, those top two could be from the same party, and could be from different parties. They're the ones who proceed to the November general election. So again, you could have two of the same party or of opposite parties, and sometimes we even get a third party candidate in there. It's interesting by way of background that this measure, because remember, we had to change our constitution to allow that top two primary. Then state senator, later becoming lieutenant governor, Abel Maldonado, and then Governor Arnold Schwarzenegger had advocated for it. And as part of agreeing at that time, the California Constitution required the state budget to be passed by a supermajority or two-thirds vote of both houses of the legislature, and Democrats in neither house had a two-thirds majority. Today, of course, they have what I call super duper majorities, about 75% in both houses. And so Governor Schwarzenegger and Senator Maldonado at the time, as part of a budget deal with the Democrats in order to get that two-thirds vote, and the governor's signature, of course, on the budget, wanted to pursue this top two primary. Why did they advocate it for it? for it. The two of them in particular, and other proponents of a top two primary, argued that the candidates would have to moderate their positions because now all voters could vote for them. Democrat or Republican in an open primary could vote for whomever they wanted in that primary. And so that was their belief. Um, I'll leave it more to the political pundits to decide, but I think generally from a lot of people around the Capitol's view that that moderation has actually not occurred. Nonetheless, that's how it came about, part of a budget deal. And so we continue to maintain a top two primary. We've talked a little bit about, the term limits law. I think that's also a unique aspect. There aren't term limits at the federal level, of course. There have been some start and stop efforts, including in California, to try to put forth an amendment to the U.S. Constitution, which of course requires ratification of the states. So far, those haven't happened. Some Republicans in the House have taken to self-imposed term limits, primarily how long they can serve, like as a chair, for example. But as I gave a little bit of background on Prop 140 in 1990 and then the revised version, has it been successful? Don't know. I know that when the legislature placed on the ballot the revision uh, that is current law in the Constitution with those 12-year limits, right? In either one single house or in a combination of them. The general argument was, hey, look, we'll get legislators to start thinking more long term. When you were in the assembly for a maximum of 6 years, I mean, wasn't a lot of time. You were already thinking about the next office. And certainly you didn't have any time to, for example, evaluate what happened with your legislation. Um, there wasn't, so there weren't many like informational or investigative or oversight hearings by the legislature. There was criticism that legislators were not thinking long term, right? Well, I don't care what the long term implications of this are because I'm out in 4 or 8 years or 6 or 8 years in either house. So, what do I care thinking long term? Um, that they would develop long term expertise, in other words, legislators, if they're going to serve in one house for 12 years, well, then they're going to sit on a committee or chair a committee for half or more of their term. They'll become real experts. Fewer and fewer people will run for other offices, et cetera, et cetera. We have the first 12 years because it was adopted by the voters in 2010. And so the first 12-year term limited folks hit in 2024 in last year's elections, of course. What did we see? Believe it or not, less than a third of the first 12-year babies, 12-year term limit babies, were in office at that time. Some got to the some folks got other offices, right? They ran for mayor, they ran for board of supervisors, they ran for federal office. A lot of members of Congress. Some got some interesting appointments. Ed Chow from LA, Superior Court Judge. David Chu in San Francisco, appointed city attorney. Um, Shirley Weber got appointed to be Secretary of State for California, filling the vacancy of Alex Padilla, and then ran last year on her own and got elected to her own 4-year term. Some went to the private sector. Lorena Gonzalez became the head of the California Labor Federation. So 2/3 of the first group of 12-year term limit babies didn't go the full 12 years. So some of those things about serving on fewer committees, spending more time in their district, conducting more oversight, uh, thinking long term, sticking it out for the 12 years. Shall we just say that the jury is still out, for lack of a better description? Anyways, the other unique thing, and it's certainly been in the news in the last couple of months, is the voters' adoption of the Citizens Redistricting Commission. In most legislatures around the country, the legislature, the legislative body, the state legislature, that is, of course, has the power, the authority to draw both the U.S. House seats, except for like Wyoming and one other that has a single person, but and then of course their state legislative seats. So in 2008, the voters did this the first time, but they did it for Assembly, Senate, so the legislature, and the Board of Equalization. That was it. In 2010, the voters came back and amended Article 21 to add the congressional seats. So between 2008 and 2010, you have all four types: Assembly, Senate, BOE, and the U.S. House being drawn by the Citizens Independent Redistricting Commission. And Article 21 sets forth things like how are the commissioners selected and by whom? What is their guidance? Of course, federal law, but there's some additional guidance in there as to how they draw those districts, et cetera, et cetera. And the idea here, of course, critics critics of the legislature drawing seats, of course, generally argued that it's an incumbent protection plan. In other words, every 10 years, based upon the federal census, that these districts would get redrawn or redistricted to protect the existing legislators so that they would get reelected as opposed to making them more competitive. In fact, I and many others would argue the last time that we truly had competitive districts was after the 90 census, so before the Independent Commission, but it wasn't the legislature who drew those because the Cal Supreme Court actually struck them down. And so the California Supreme Court selected judicial masters, they called them, and judges actually drew those districts that were used in the 92, 92, 94, 96, 98, and 2000 elections. Has the Independent Redistricting Commission resulted in more incumbents losing their seats? Not really. Still pretty much, there are very few what we call toss-up or the so-called purple districts. Most are pretty much, Democrat or Republican for the most part. So there aren't too many seats. But ultimately, the idea is let's not have the legislature and legislators acting solely out of their self-interest. So the voters, of course, took this job out of their hands. If you look at the 2008 and 2010 campaign messaging, like the arguments in support and in opposition, et cetera, and some of the mail, it does say like, hey, we're taking the job out of the legislature and its partisan hands and creating this independent citizens redistricting commission. They won't care about, things like incumbency, and they'll draw them in a nonpartisan manner and create more competitive seats. Frankly, Republicans, and you can see that today in some of the campaigning, right? Who were the biggest proponents? Governor Schwarzenegger, he's not actively campaigning against Prop 50, but at USC, where there's the Schwarzenegger Institute, and he teaches there from time to time, he obviously talked about his opposition to it. And Charles Munger Jr., who primarily funded the 2008 and 2010 initiatives on the ballot that the voters approved. He's put $30 million so far. He pledged more. We'll see if he comes through, but that's an aside. But he primarily funded the campaign to get those two ballot measures in place. And why did they actively campaign for it? Because they believed that an independent commission would result in far more competitive seats. And of course, they hoped for an increase in Republican Party members being elected to the Assembly, the Senate, and the legislature, and of course in the U.S. House of Representatives. Has that been borne out? No. In fact, Republicans have lost more seats in the Senate, the Assembly, and the House of Representatives at the federal level since the Independent Citizens Redistricting Commission. So, sort of like, frankly, the term limits law, the proponents of term limits, the proponents of the term limits of term limits, and the Independent Redistricting Commission both made these arguments how it would result in, well, we've gone over it, fairness, blah, blah, blah. And obviously that has not occurred. In fact, Democrats have, increased their ranks. And there's even been some Republicans, mostly privately, but there have been a few who have gone on record, but most of them complain privately that, um, you know, maybe having the legislature draw the boundaries would be more helpful to them. The final part about again, my description about unique aspects, Prop 34 was placed before the state's voters in I want to say late 90s. I should have that date. I apologize. Anyways, a big campaign finance reform measure. And it did some important things. We didn't have contribution limits before. And this provides contribution limits for candidates to the legislature and to the 9 constitutional offices. For example, $5,900 is the maximum that can be contributed for the primary, and $5,900 for a member of the legislature. I think it's 22,500. We could look it up for governor. So obviously higher for those running for statewide office. And those, by the way, are adjusted every 2 years. And so that amount started off substantially lower. I don't want to say as low as 1,000, but it was down there. And it's gone up considerably. I mean, it was just a few election cycles ago that it was 4,100, and now it's up higher. Anyways, so there are now contribution limits in California law and have been for quite some time now. It also, of note, prohibits lobbyists from making campaign contributions for those that they're registered to lobby. For those who have any exposure to lobbying at the federal level, most contributions are either made by PACs, whether it's a labor union or Google or whomever, but also they are made by individual lobbyists themselves. I've jokingly said lobbyists don't have the same First Amendment rights as citizens generally do, so we can't contribute at all. So, for example, I'm registered to lobby the governor's office and the controller and the treasurer and, of course, the legislature. So I, Chris McHaley, cannot make any contribution to somebody that I'm registered to lobby at the state level. I think another interesting distinction, primarily between federal and state campaign laws, In California, corporate contributions can be made directly by the corporation. So again, my example of Google, Hewlett Packard, Meta, of course, within the limits, but they can make a corporate contribution to a candidate subject or a ballot measure for that matter to the contribution limits. At the federal level, of course, corporate contributions are prohibited. And so you have individual contributions that can be made by an employee of a corporation, by an officer of a corporation, the president, a board member, etc. And usually they do that by creating a PAC and they, contribute to that PAC. But at the federal level, Meta, Google, et al., Oracle, etc., they're prohibited from doing so. The other thing is at the state level, we do what's called a plurality vote in a single winner contest. How does that differ? Well, the other two types, meaning, of course, that the top vote getter wins, right? At local level, there are two other types, not used very frequently, but ranked choice voting. The city of Oakland has long used that, for example, and a number of other local jurisdictions. There's also the so-called multi-winner voting. For example, a lot of city council members, they run citywide as opposed to individual districts, although that's where most of them are going. But it'll be like three of the seven council seats are up in 2026, and then four of them are up in 2028. As many people who want to run, and the first three top vote getters win, and they get to fill those three slots. That's a so-called multi-winner voting scenario. So at the state level with our 9 constitutional offices, there are also a single winner contest, right? But again, some local jurisdictions use that multi-winner election or ranked choice voting. So the federal constitution, of course, that sets forth the provisions that are applicable. So we can't have, so in the state constitution, in Article 4, for example, we have what are the requirements, age, residency, etc., for people who are running for the state legislature. We also have that for governor, and the same applies for lieutenant governor. We don't have them for the other offices, but we do for governor. We, the state of California, neither in our constitution nor by state statute, have any authority to impose any other sort of requirements or thresholds than what on people running for federal office. That's in the Constitution. So if you want, federal provisions, if you want federal term limits, blah, 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 all that, you have to obviously amend the federal Constitution. We also have the Fair Political Practices Commission that plays a role in the elections world, not just in the political reform or the political law aspects. And that is because the FPPC reviews and, of course, can enforce our election laws. And they're able to, for example, administratively fine somebody who violates, like if you late contribute and failure to disclose contributions, all those types of things are available. California has in statute a voter bill of rights. Again, there are significant efforts at the state level to ensure that voters are can easily register to vote. We even have same-day registration in California. We have the so-called motor voter law, which is when you sign up either online or in person, if you've done either of those, part of HAVA, You will note that, of course, they ask you about, do you want to register to vote at the same time, using your license information to do so. We have things like voluntary candidate spending limits that generally do not get abided by. Provisional voting and write-in candidates are authorized in California. There are specific rules. Provisional voting is when somebody shows up at the, um, like what they think is their polling place. Their name's not on the list. They vote a provisional ballot. Those are then reviewed. Maybe somebody was at the wrong polling place. Maybe they moved to Sacramento County from Yolo and forgot to re-register in Sacramento County. And so if it checks out that they were, properly registered, or maybe the printout from the county, yes, that person is registered to vote at that address. For some reason, there was a glitch and they weren't on the printout, for example, their vote will be counted, et cetera, et cetera. The California Constitution also provides for a number of nonpartisan races. Um, Specifically, there's one at the statewide level. So, Secretary of State, Attorney General, Controller, Treasurer, what you would probably think generally should be nonpartisan, actually are. The Superintendent of Public Instruction, the SPI, that race is nonpartisan. At the local level, however, school boards, local government, so that's city council, board of supervisors, sheriff, county auditor, county assessor, etc., and school districts, of course, those are all by state law nonpartisan. Okay. There are extensive rules in the elections code dealing with everything about who qualifies as a voter in California, how do you register to vote, where do you do it, what happens with the voter records, how do people get removed from the rolls, all these things. Pursuant to federal law, we have provisions related to what about those in the military, obviously serving outside their county, for example, maybe outside their state and maybe outside the country. And of course, those who are overseas voters, right? A student studying abroad, a person temporarily living abroad or working abroad. Those are all we have provisions. The general rule is that their ballots must be marked by election day and then received within 7 days. There are some states that have lower, 2 to 3 days. There are some, I'm aware of at least one state that has 14 days. Again, must be postmarked by election day, but can be received up to, at least in California, 7 days after the election in order to be counted. Yes, it is true that if you have it date stamped by the post office November 4th, for example, in the Prop 50 special election, and it comes in, 11 days later on the 15th, it will not be counted. So even though it was postmarked, it's not open-ended. So again, some states have fewer than California 7 days. Some of them have, longer periods. There's also a lot related to ballot measures. And again, this stems from Article 2 in direct democracy for initiatives and the referendum process, referenda plural, but in Article 18, which we'll cover in the next course, but in Article 18, the legislature also has the authority under the state constitution to place measures on the ballot. So they can place constitutional amendments or changes on the ballot by a 2/3 vote of both houses, and then a governor doesn't act on them. Then it goes to the ballot and the voters vote on it. That's what Prop 50 is all about. It was ACA 4, Assembly Constitutional Amendment number 4. And ACA 4 has now become Prop 50, but the legislature put it on the ballot by a 2/3 vote of both houses. They also have to put bond measures. So last November, we had two bond measures. Prop 4 was for climate change, a $10 billion bond. And the other one, it was 5 or 6, was a $10 billion bond issuance for rebuilding, retrofitting, et cetera, education facilities in the state. Those two ballot measures became propositions, right, with a number. They were placed on the ballot by statute. So a bill that got passed by the legislature and signed into law by the governor, that's how those got on the ballot. Well, there's a whole section of the elections code dealing with ballot titles, arguments for and against, who gets to submit them, who gets the rebuttal. Because remember, there's a for and there's against, and there's a rebuttal to the for and a rebuttal to the against. So there are 4 sets of arguments for ballot measures. There are specific voting procedures in a California statute for voting on a referendum petition. Remember, the referendum is the power of the people to overturn a statute enacted by the legislature. And then, of course, the third form of direct democracy, the recall. Recall is allowed at the state and local levels under the state constitution, not under the federal. So federal candidates, the president, are never subject to recall because the U.S. Constitution doesn't provide it. The last successful recall of a state official, of course, was in 2003 with then Governor Gray Davis, who is replaced by Arnold Schwarzenegger by a plurality vote. So whoever was the highest vote getter. So when Schwarzenegger got elected, he got like low 30%, as I recall, 32, 33% of the vote, something like that. He didn't need 50% plus one. It's just whoever is the highest vote getter. So a recall petition, by the way, no, we'll get into that in direct democracy. I'll let it go. Also, when there's a vacancy in the legislature, all the constitutional offices, they are replaced by a gubernatorial appointee who is subject to confirmation by both houses of the legislature. So remember, most gubernatorial appointees are subject to Senate confirmation only. The other 8 constitutional offices are filled by gubernatorial appointment confirmed by the 2 houses of the legislature. Or if they don't confirm, then they take office anyways. But for the legislature, the governor cannot appoint somebody. He must call an immediate election. The legislature by statute has defined that to mean 14 days, and then those elections are filled. There is a primary, so if you don't get 50% plus 1, then you go on to a general election for the special election to fill the legislature. A unique provision also in the elections code is on income tax disclosures. So you may recall that President Trump in the first go around argued that or said that he would disclose his finances and his tax returns. So when he didn't, the California legislature enacted a statute that said people running for president and running for governor must disclose whatever, a couple of years of income tax returns. It was challenged in federal court. And as you can probably imagine, the federal court said you can't impose that. The federal government can, but not, and in fact, some would argue that even Congress couldn't because it's not in the Constitution. But so that provision was struck down. The gubernatorial candidate income tax disclosure remains there. So, California also allows election contests at the state and local levels. So somebody can challenge the result. That is, I'm sorry, that's a contest. Sorry. Recounting. Recounts can occur with any of the state offices, constitutional, legislature, BOE, and of course, local jurisdictions. There have been several instances of recounts in state legislative offices. In the vast majority, the originally declared winner is ultimately upheld as the winner. But every once in a while, a recount does in fact result in a change. There's also provisions for election challenges or contests. So under state law, you can challenge in court for valid reasons, of course, a local race, a state legislature, a state legislative race, even one of the constitutional offices. But again, there's a fair amount of law in that regard and specified reasons. A number of local jurisdictions have independent redistricting commissions. The vast majority do not, meaning in most counties and most cities by far, the local body gets to draw the lines. But the legislature by statute, in fact, there was at least one, maybe two, that the governor signed this year. So slowly but surely, some of the local jurisdictions are creating independent redistricting commissions. The legislature puts those into statute. Uh, we're gonna, since our hour is coming to an end, I'm gonna have to schedule a second one for political reform or the political law stuff. So let me just conclude in the last minute or so. As you might imagine, the California Elections Code has some provisions related to libel and slander. One is for verbal, the other is written in political campaigns, and sort of what is the standard. As you can imagine, we want sort of broader um, provisions under libel and slander in political campaigning. It's really the truest form of free speech. We don't want candidates to, you know, uh, clearly and knowingly lie in on paper or verbally about a candidate, their opponent, for example. But we also are going to, not strictly limit that because, again, probably political campaigning is one of the, foremost forms of protected speech under the First Amendment. And then the last item in the elections code, as I mentioned, we actually have, they call them penal provisions of the elections code. So whether it's voter registration, election campaigning, the process of voting, or direct democracy, there are actual provisions of the elections code that make it a criminal offense for violating, obviously not the whole elections code, but certain specified provisions set forth here. But again, it deals with everything from fraudulent voter registration, to fraudulently claiming that you can vote when you don't, somebody who votes multiple times knowingly, et cetera, et cetera. Those can actually result in criminal prosecution for folks who violate those specified provisions of the California Elections Code. So that's the end of sort of my spiel about California election law. I'll get on the books because I have the other ones, direct democracy, rulemaking and advocacy, etc. But I'll get that on the calendar soon to talk about the political law aspects. Just some things that I find particularly unique or relevant, and things that Richard Rios didn't necessarily cover in his guest lecture last week. I don't know if folks have any question. Otherwise, I will wrap it up. And of course, this is recorded, so it'll be available within the next 24 hours or so on the Canvas website under the political and election law section. Okay. All right, we'll have a wonderful evening. More in this course, of course, we've got, that was dumb. The course, of course. We have several, guest lectures because we've got multiple components. Brandon Castillo, a well-known campaign consultant, is going to talk about direct democracy. He has, well, he'll tell you, but he's run quite a few successful statewide ballot measures, both the side and the con side. And then Lindsay McNeil, one of the senior staff attorneys at the Office of Administrative Law, is going to talk about the rulemaking process. And she's actually going to do a condensed for 1 hour, a condensed version of the training that she gives to state agency personnel who are developing regulations and are going through the rulemaking process that's set forth in California's APA, the Administrative Procedure Act. So we've got two great guest lectures coming up. And then, of course, mine will try to focus on some of the things that our guest lectures didn't necessarily cover. If you've got any questions as we go along, either on your readings, your essays, your quizzes, or any of the lectures, feel free to email or reach out, and happy to do office hours or anything like that. Several folks throughout the last few months have done those, so we can get together by Zoom or just on the telephone if you desire. Otherwise, signing off for tonight. Thanks for those who are able to join live, and look forward to seeing you all next week.